Right. Anthony Rico, is that what I got next?
Let me go grab him, Judge. We had to remove him. It'll be one moment.
There's always one. All right, Anthony Rico, a criminal trespass. All right. All right. Mr. Rico. Are you Mr. Rico?
Yes, sir.
Good afternoon. My name is Walt Weaver. I'm the judge of Potter County Court of Law number 1. I'm going to be hearing your case today. I've reviewed your plea papers, Mr. Rico. It appears to me you're ready to waive all your constitutional rights in exchange for a plea bargain agreement. But you do have an absolute constitutional right to appear in my open courtroom and face your accusers. Or you could also choose not to use that right as well and agree to appear by video. Are you agreeing to appear by video?
If I can, man, you can just like figure it out in court and I guess.
Are you saying you don't want to do this on video?
I'm not trying to be in court hearing and doing stuff on here. I just ain't got
Mr.
time.
Rico, it's real simple.
I don't got time to be here, man. If you can, just do your job or do whatever you're doing or something, man. But I don't really care what you do, man.
I'd love to do my job, but part of my job.
Not my job, dog.
Sure.
It's not my fucking job, all right? I don't give a fuck what you look like. You know what I'm saying? Your job is gay.
I'm going to hold you in contempt.
Hey, bro, I don't give a fuck what you talking about, man. All right? I don't give a fuck what you talking about, man.
Bye.
Anthony Rico had one job: keep quiet and take the plea deal that would have sent him home. Instead, he snapped at the judge, calling his job gay and cursing nonstop. Within seconds, Rico managed to turn a simple appearance into contempt of court. The judge, unfazed, calmly dropped the hammer. This is a textbook example of how opening your mouth at the wrong time can turn freedom into extended jail time.
Subu, get a job. It's Rico.
Well, do we need to preserve this as evidence now since that's resisting? All right, don't delete the YouTube video. That's unfortunate. Hey, Ethan. Keep them coming, man.
I apologize, Your Honor.
Oh, it's not your fault. That's part of our part and parcel. Boy, he's so little, and look how much people he's got. Could you please put him, Miss Morris, on a transport next time so we can get it done? Boy, if that's not the funnest name I've said all day. Man, it's too bad Mr. Rico could have gone home today. He decided he'd rather stay.
He might have got a new prosecutor today.
Well, it's all live. You saw him fight the deputy. Technically, he's under arrest in a jail. Do you have to prove that?
Even after Rico stormed off, the judge slipped in his own jabs, mocking Rico's bad choices with dry humor. The real kicker? Rico could have walked free that day. Instead, his outburst guaranteed more jail. The judge reminded everyone, sometimes silence is the smartest legal strategy. Rico proved the opposite, talking himself right back into a cell.
Good morning, Your Honor.
Good morning. Can I have you state your name and date of birth, please, for the record?
Mark Briggs, 10/3/1964.
Mr. Briggs, you're before the court today making first appearance, Raymond, on 2 charges. The first is malicious mischief in the 3rd degree. It's a gross misdemeanor subject to 364 days in jail and a $5,000 fine. Second is harassment, domestic violence. That's also a gross misdemeanor subject to 364 days in jail and a $5,000 fine. Because the charges have domestic violence enhancements, they are something where if you're convicted of them, it would result in your inability to possess firearms.
I don't own a firearm. That's
okay.
what I told
Again,
him.
I have to let everybody know whether you have guns or not. Because these are criminal charges, sir, you have several important rights today, including the right to remain silent, the right to a speedy and public trial, and the right to an attorney. Would you like to be screened today, sir, for a court-appointed attorney?
No, sir. I'll be getting my own.
Okay, sounds good. So enter a not guilty plea today.
Yes, I do have something I want to add, though. I was denied due process.
So you have an attorney. We're going to hire an attorney. Your attorney would probably have you exercise at this point your right to remain silent.
I don't want to exercise my right to remain silent because I have nothing to hide. So I was denied due process. I have paperwork that proves that I owned the car before I was married. So therefore the car is mine. And no, since we're in separation, no judge has divided property yet. So technically the car is still mine. So I wrote on my own car. That's a fact. Here's the paperwork. I
We're
sit
not
down at
having
the
a
bank.
trial today.
Well-
We're having your arraignment.
Okay.
You're entering a not guilty plea.
I was denied
You've
due
told-
process,
hold on,
sir.
Hold on.
You said I could
You've told,
speak.
no, I
wanna
didn't. I said you should exercise your right to remain
I choose
silent.
not.
Enter Mark Briggs, facing harassment and malicious mischief charges. He was warned about his right to remain silent, but ignored it. Instead, he immediately admitted writing on a car, an element the prosecution needed. In seconds, Briggs turned his arraignment into free evidence for the state. His insistence on due process violations only dug the hole deeper, showing exactly why defendants should never argue their case at arraignment.
Making factual statements on the record.
That's my discretion, sir. Because I believe there's Fourth Amendment charges. I was denied all kinds of rights, and I will be coming back with a vengeance. I have
Are you
paperwork.
threatening the court?
I am
sir?
not threatening the court anything. I'm not threatening anybody.
You just-
I have the
you just
right
said
to
you
sue.
were coming
I have
back
the
with
right,
a
I have the
vengeance.
right to sue this city, and that's what I just said. So if you want to take that farther than that, that's up to you. I did not say that. I'm
You
making
said
it
you are
clear.
coming back with a vengeance.
With an attorney.
On
It
the
doesn't have
record,
anything to do
yeah.
with me. That's not a threat to you. The city. I said I'm suing the city. So you do what you want today. Go ahead and hold me in contempt. Go ahead. I'm suing the city. I will be suing the city. If you will take that as a threat, then that's fine. I will be talking to the city attorney. I've already talked to the city. I'm talking to people. I talked to the police chief already.
Yeah, I've seen how you've conducted yourself. so
Yeah,
far.
that's right. Because I'm being wronged. It's my house. She had no business being there. And she hasn't even lived there for 6 months. She hasn't paid a bill for 8 months. She can't just come there. I have rights.
You do?
Just because she's entitled to
So
be
again,
able to
we've-
be on the
again, we've
property
talked
doesn't mean
about-
she can just come.
We've discussed your rights today. We're not going to litigate your case today.
Do I have the option to
This is-
speak with the city attorney
This
as
is a
well?
criminal court.
Do I have the option to speak with the city
Not once
attorney?
you say you're going to be hiring an attorney.
Do I have the option to speak with the city attorney? I'm not hiring an
Not
attorney.
today.
I want to speak with the.
Briggs spiraled fast. Claiming he'd been denied rights, he promised to come back with a vengeance, then insisted it wasn't a threat, just that he'd sue the city. The judge pressed him on the language, but Briggs kept running his mouth. He refused a lawyer, demanded to speak to the prosecutor, and openly admitted to conduct tied to his charges. Every word became another nail in his legal coffin.
Today.
Okay, when would I be able to do that?
That's me, sir, and I will give you my card.
Okay.
But we do have some release conditions we will be requesting.
Okay. Go ahead, Ms. Carmen.
Yes, Your Honor. We are requesting a formal no contact order with victim notification.
It should have been me filing.
Hold.
She's
Please,
harassed
sir.
me.
Please, sir,
All right, go ahead.
the facts of this case are highly concerning with regard to the threats that were made. These folks are in the midst of a dissolution. Statistically, through peer-reviewed literature, that is one of the highest risk times for partners who are splitting for domestic
Well, what about the time
violence.
I got punched in the chest 5 times? Nobody did anything about that, and I reported it to the officer. Upon arrest, I told him 2.5 months ago, I've been punched in the chest. I will take a lie detector test for that and pay for it. And I received
At this point,
nothing.
the city attorney is making her release recommendation. You need to let her finish.
I was denied due process. You guys didn't take my complaint. So you didn't even take my complaint. And then you don't want me to call it racism. You didn't even take my complaint.
The only thing we are doing today, sir, is you have entered a not
Well, there
guilty
should be
plea.
equal treatment under the law, and I have not
You're not
received it.
litigating your case today. I've already told you that. You've seen every other person come up here. I've entered not guilty pleas. I've set
Well, I
release
want to put this in
conditions.
the record
You
is,
signed
can I give
it.
this to the attorney so she can follow up on this? This is my proof that the car is mine. There's been no dissolution. No court has divided property.
So would you like me to continue?
Yeah.
So again, we are asking for the victim notification. There was an ex parte no contact order approved in Clark County Superior Court this week. However, as of yesterday, it had not been served, so there is not formally protection in place for the victim.
I don't go to her. I am at my house. She came to me. I never go to her. So why is the order against me when I don't even deal with her?
Please let the city attorney finish her recommendation. So we're walking on a very fine line right here with your conduct in court today.
Okay, I'll stop. Sorry.
Thank you. Go ahead, Ms. Carmi.
So yes, Your Honor, and while there's no in-state prior history with domestic violence, there is a older mid-1990s arrest for assault 4. So there is some history there. We think all of the circumstances in this case, particularly with regard to statements of harm to the victim at this time, warrant that victim notification.
I don't even go to Oregon, sir.
I will
She lives in
add,
Oregon.
I will add, because Mr. Briggs has brought it up, we are not seeking to remove him from the home that he is residing in.
How you gonna, she don't even live there. Are you kidding me? She doesn't live there. I paid the mortgage there for the last for 4 years. I paid the mortgage, and I can prove that.
Mr. Briggs.
I'm trying, you're gonna remove me from my home? What are you talking
I'm
about?
saying she is not.
Why are you even saying that?
Because
She don't live there.
When the prosecutor requested a no-contact order, Briggs exploded. He argued about being punched, accused the court of racism, and claimed nobody listened to his complaints. The judge reminded him repeatedly that arraignment isn't a trial, but Briggs kept insisting. His nonstop interruptions only made him look unhinged, undermining any credibility he thought he had. Judges don't forget behavior like this. It sets the tone for the entire case.
I'm bringing this up is that the victim has requested a civil standby so that she can go get her personal belongings from the home.
Property has not been divided by the court. She has her personal items and her personal belongings. And then the court has to divide the property. That's what I've been waiting for. I've encouraged her to file the divorce papers, sir.
I will be finished here shortly, Your Honor. The proposed NCO that we have drafted after contacting Battleground to make sure this is something that they could do.
That's against the law. No way.
Is that she can call for a civil standby where they would go to Mr. Briggs' home. She has the same 15 to
She
20.
can't come there and just take whatever she wants out of the home. It hasn't been divided by the divorce court. I don't have a problem sharing, but it's an argument every time.
So one of the things that you've brought up, Mr. Briggs, today is that there was likely separate property, it sounds like, prior to your matrimony.
Yes, sir.
My assumption, and I could be wrong, my assumption is that the other party also had separate property prior to the matrimony. So yes, you are right. The court, if the property is shared property, the court certainly cannot order a person to go in and take shared property. You are correct on that. The court, however, can, if there is separate property of hers in the residence, allow her to retrieve separate property.
But she's taken my property. That's the reason why I don't want her
I
in the
don't know what
house.
she's going to do. We're talking about prospectively, sir, not retroactively. When she shows up at your home and takes her separate property, that would be allowed. Do you understand?
That's actually not allowed because
Yes, it
I
is
still,
allowed.
no, it's not. No, it's not. No, it is not.
The prosecutor clarified. No one was kicking Briggs out of his house. They just wanted his estranged wife to collect personal items with police supervision. Briggs twisted it into a property battle, yelling about mortgages, stolen photos, and even accusing her of being possessed by a Jezebel spirit. Every emotional rant strengthened the case for protective orders. Instead of silence, Briggs gave the judge every reason to doubt his stability.
He could have asked
that
for
were separate property of hers.
She does have her
Prior
property. The
to
only thing is,
pulling-
sir, she didn't even have any place to put the stuff. She's in a bedroom at her mom's. Now, she can have the kitchen table, which is hers. I don't have a problem with that. I've held nothing from her. I don't want to fight. The reason why we have not been around each other is because of what happened the other day. I didn't want that to happen. I've made many statements to family and relatives that I refuse to be around her. I believe she's demonically possessed by the Jezebel spirit. So I don't want her around me. There's a visceral reaction that I haven't felt around a person in many years. If I'm from here to her, I want to throw up. I literally cannot be around her. And I've required that she not come to the house. She came to the house because I refused to get the HELOC with her to help her pay off her bills. So she came to the house the next day, and then that's when everything started. I was sitting there with my brother-in-law, drinking beer by myself, like I always do. I didn't go to her. She came to my house. And she has forfeited, I haven't proved it, but she's forfeited her right to the property. She hasn't paid a single bill there in 8 months. And when she left, the moment that she took her and got a new bank account at Columbia Credit Union, that's the day of separation. That was over 8 months ago. She cannot just come to that property. She cannot.
So, Your Honor, I have, if you do adopt it, change the language in the civil standby to indicate that the law enforcement agency would assist the protected party in obtaining personal belongings.
She has her personal belongings, and not only that, she stole every picture off the wall, which she was not entitled to. She stole all of our financial records, which she was not entitled to all of it. So now I'm in a position when I do go to court to battle her, all the financial records are in her possession because she stole them out of the house. But when I got arrested, they wouldn't even let me go and secure my home or give them any instructions on what to do with the property. I said, don't let her in there. I got silver. She's going to steal it. And she went right in there and started taking everything off the wall. She left me 2 tablespoons and 4 teaspoons. She knows I love tablespoons.